Your Excellency, the President, Nana Adodankwa Akufo-Addo, Your Royal Majesty, Otumfuo Tutu II, King of the Ashanti Kingdom, Nananom and Nana Hima hearing present, the Vice Chancellor, members of the Council of State, Honorable Godfred Yeboah-Dame, Attorney General and Minister of Justice, the Regional Minister of Ashanti Region, Honorable Simon Osei-Mensah, Honorable Ministers, Deputy Ministers, Members of Parliament present, MMDCs, Heads of Security Agencies, my Lords of the Superior Courts, eminent clergy, law deans, Director of Legal Education, National and Regional Executives of the Ghana Bar Association, distinguished ladies and gentlemen, good morning. I am greatly delighted. Oh, my husband reminded me this morning to acknowledge him. Mr. Francis Tokonu. Mr. Francis Tokonu, fourth gentleman, good morning. And then we have peace at home. I am greatly delighted to join you this morning to open the annual conference of the Ghana Bar Association. The lineup of conference activities spanning spiritual dedication, intellectual discourses, and learning sessions, sporting activities, deliberations on emotionally disturbing issues, and the usual dancing sessions that remain unequaled in exhilaration, which I miss very much from bar conferences, reflects the buoyant strength of the Ghana Bar. Clearly, the Ghana Bar Association continues to grow from strength to strength. To the executive, thank you for keeping the torch of excellence high. The 2023-2024 legal year was a mountaintop experience for me, following the passage of the responsibility of Chief Justice to me in June 2023. Assuredly, God has been with me through this first year in office. I have experienced the grace of good health, sound mind, and the cooperation of the executive, the legislature, the judiciary, the bar, and the good people of Ghana. I am extremely grateful and can only say it in what must be two of the most impactful yet simplest words known to human vocabulary. Thank you. Your Excellency, Your Majesty, distinguished ladies and gentlemen, the theme of this year's bar conference, Peaceful, Fair and Transparent Elections, the Key to Sustainable Democracy, unquote, speaks to what is on the heart of every Ghanaian. The electoral process is a legal process. It is conducted in accordance with a statutory framework. Equally, there are settled legal norms for determining any disputes arising therefrom. This requires that stakeholders come to the electoral process with full recognition and appreciation of the legal regimes surrounding it. Who qualifies to stand as a candidate? What makes a vote valid or invalid? Which court has appropriate jurisdiction to settle an originating petition or application invoking the supervisory jurisdiction of the court? What is the proper procedure for commencing all types of claims. The judiciary has always played its part in the electoral process by not only resolving disputes over registration, disputes over parliamentary elections, and disputes over presidential elections, but also maintaining a standing elections management committee chaired by a Supreme Court judge that works actively with all relevant domestic and international organizations to respond to issues raised during and after the electoral process. Now, I'd like us to acknowledge His Lordship Justice Bafuboni, who is the current chair of the ECM. In every election cycle, commencing with the opening of registration, this committee tours the country, training and overseeing the work of judges, adjudicating related disputes. Since 2008, the judiciary has also produced a compendium of relevant statutes and case law as a guide for stakeholders. This year, we have moved from the one-volume compendium to a three-volume compendium, allowing for a good sampling of the vast stock of jurisprudence that has developed from the 30 years of the Fourth Republic. I believe that we will be ready to launch it in a few weeks so that stakeholders can familiarize themselves or refresh their memories with the material available. In addition, the Rules of Court Committee has worked on amendments to the High Court Civil Procedure Rules CI 47/2004 to introduce dedicated rules on the resolution of parliamentary elections. It was noted in previous election cycles that the absence of a dedicated time frame for resolution of parliamentary election disputes and the subjecting of such disputes to the regular procedural rules of court led to horrendous abuse of the adjudicatory process. These amendments seek to address this phenomenon and introduce further measures for expedited hearings, such as electronic service of court processes. Further amendment of the Supreme Court Rules CI 16 to improve the time frame for hearing of any presidential election petition, which I hope will not occur, is also in progress. My humble view, distinguished ladies and gentlemen, is that the relatively peaceful journey that the Fourth Republic has been is anchored on this consistent addressing of weaknesses found in every election cycle. But as we know, sustaining the democracy calls for more than election cycles. It calls for building strong institutions as well as a population that is committed to the rule of law. Whether people function as political activists, media activists, or legal activists. As long as actors in the electoral process commit themselves to honor legality over private determinations, our democracy can only grow from strength to strength. Your Excellency, Your Majesty, distinguished ladies and gentlemen, we will all agree that law is the fundamental infrastructure of society. It is needed to plan cities, towns, and houses. It is needed to guide the management of rivers, forests, and every form of human habitats. It is needed to determine and define governance structures for society, whether as arms of government, institutional, corporate, or traditional governance. And it is needed to guide every form of human relations, from family commerce to justice administration. To quote Roscoe Pound, justice is always according to law. Soon after I took office, therefore, I crafted a vision statement to guide my leadership journey as Chief Justice and to enable all stakeholders to work with me towards defined goals. On 8th April 2024, I presented this vision statement at the Leading Justice Conference. LEAD is an acronym for law, ethics, assets, digitalization, and due process. My expectation is that when we, as lawyers, judges, law faculties, Nananom, and all stakeholders in justice administration work together to increase the culture of legality, ethical conduct, and development of critical infrastructure, such as digital tools for the mandate entrusted in justice delivery, we shall achieve the efficiency and just outcomes that the nation deserves. Although all personnel that support the justice delivery function of the judiciary are experts in different fields, more than 99% of our supporting directorates, officers, and staff do not have the requisite training on consideration of what affects legality, due process, and validity of court processes and proceedings. So it is with the supporting staff of law offices and legal departments of other institutions. It is from this perspective that apart from resolutely leading the development of manuals, guides, and directions for court processes and proceedings, I also set the Judicial Training Institute the task of producing curriculum for paralegal training of all judicial service staff. The first batch of this material is ready for use, and we are preparing more faculty members to assist in delivering consistent training for all our 7,000 plus staff. I am excitedly looking forward to staff of judicial service becoming properly trained paralegal secretaries, paralegal accounting personnel, and registrars who are equipped as judicial officers, as is the norm in many jurisdictions. I also note other private paralegal training initiatives and the paralegal program at the Legal Aid Commission and with the Ghana Prison Service to expedite processing of representation for persons unfortunate to find themselves within the grips of the criminal justice system. I wish to take this opportunity as chair of the General Legal Council to invite the bar, academia, corporate Ghana, and Ghana Tertiary Education Commission GTEC to work with the General Legal Council to mainstream paralegal training into appropriate national learning programs so that non-lawyers who work in law firms, legal departments, and institutions that must produce legally valid processes and documentation are properly equipped to support the work of the legal profession. Clearly, it is more than high time for us as a nation dedicated to the rule of law to take a close look at how we can increase the deepening of knowledge of law and legality with the attendant culture of choosing validity and due process over arbitrary activities that lead to corruption of public processes. Your Excellency, distinguished ladies and gentlemen, the issue of ethical conduct is a matter that seems to threaten and torment each part of our nation. In the courts, we have been confronted with syndicates working to produce fake marriage and fake divorce, and other certificates for persons who seek them for purposes other than lawful and credible reasons. Very active steps are being taken to uncover and stem these practices. And I thank the Ghana Police Service, especially the Criminal Investigation Department, for their work. I would like to encourage all persons to help judicial management to stamp out such practices that only go to hurt the reputation of Ghana as an investment destination. It is also necessary, I believe, for all stakeholders in the law and the nation to appreciate that these unethical practices are found in the preparation of land indentures and other documentation by persons who have no legal training or understanding of what makes for validity. These documents often turn out to be unregistrable, leading to extreme frustration of investors in realizing the investment made in immovable property, as well as intractable litigation over land. It is my hope that when we work together to deepen knowledge on legality, threats to the rule of law that citizens labor under daily will be lessened. On the issue of ethics, I must also very unhappily refer to the consistently increasing numbers of lawyers that are referred to the disciplinary committee of the General Legal Council for unethical practices against their clients. The General Legal Council is actively working, engaging the Council of Law Deans concerning the mainstreaming of the study of legal ethics at the faculty level. There seems to be an untoward notion that the law is a route to becoming rich early. However, as officers and guardians of law, I implore lawyers to appreciate their sacred role and reduce the treatment of the law only as an avenue for wealth creation. Lawyers are expected to guide their work towards just outcomes and nothing more, of course, and to earn money from that. But it's not the other way around. Indeed, with the increasing numbers of new lawyers being called to the bar, I have very strongly requested the executive of the Bar Association to communicate to all lawyers, all new lawyers, that unless there is a clean and clear record that proves that lawyers have done pupillage, the General Legal Council will not be in a position to license them to practice law in their jurisdiction. So will it be with all conditions required for renewing practicing licenses. On the progress of the digitalization agenda of the judiciary, I am happy to report that we have actively started the digitization of appeal records so that they are transmitted electronically, thereby reducing the cost of producing multiple records manually and also making their corrections easier. We have also started the process of delivering to the nation a paperless Supreme Court and Court of Appeal registry. It is my ardent prayer that by the time I stand before you next year, God giving us all life, this process would have reached completion. I am also glad to report that the 100 new courts that continue to be delivered by the District Assembly Common Fund have taken the need for the building of new courts off the table. Your Excellency, your government has achieved this feat. We don't need any more courts. Not in the short term. Still, many courts continue to reflect inordinately high case loads. From the data received from the current 450 trial courts in operation, as at the end of August, 43 have a load higher than 300 cases on their list, and 25 have a case load higher than 500, with 10 courts burdened more than 800 cases, some more than 1,000 cases being handled by one judge. This is not healthy for the judges and all stakeholders in the adjudication process. The response of judicial management is not to seek the building of new courtrooms to solve these anomalies, but to rationalize the use of existing courtrooms to cater for areas with higher caseloads, to deploy more judges to assist with high caseloads, and to increase the use of virtual courts. This is what has led to the establishment of afternoon courts and Saturday courts. There are also as many as 63 courts with a caseload of fewer than 50 cases on their list. In such courts, we reduce staff and engage judges that travel itinerantly to sit over those few cases. In conclusion, allow me to alert the bar of my intention to start a crusade to terminate the culture of mentioning cases. This is a practice that hurts everyone involved. Citizens and lawyers, including judges, citizens and lawyers leave their businesses and homes to travel to court to do nothing except to hear the title of their case called out. With the introduction of witness statements, the period of courtroom work has been shortened, and all stakeholders in justice delivery are encouraged to use court time efficiently by fixing dates for hearing only after processes have been filed or expiration of the time statutorily provided for parties to file and serve needed processes. In those circumstances, if a party fails to adhere to the statutorily conferred time for responding with their own processes, courts will be encouraged to conduct hearings without them. My prayer is that the legal community will rally to give the nation effective court experiences so that the traumatizing history of adjournments is erased from the mind of the nation. I thank all stakeholders in the legal and justice sectors for their anticipated support as we get ready for the new legal year. I know that the tenure of the current national executive is up, and elections for new executives form part of the agenda for this conference. I must articulate my gratitude for the excellent support and cooperation that the current executive have given me this past year. Mr. President, you and your executive helped me to settle down strongly and quickly. It was a joy working with you, and I look forward to welcoming the new executive to the General Legal Council, the Judicial Council, and the Rules of Court Committee and other committees of these bodies. God bless you all, and may he make his face to shine upon the nation as we tackle the oncoming elections in a transparent manner that will sustain Ghana's democracy. On this note, I declare the 2024-2025 Annual General Conference of the Ghana Bar Association duly opened.
Thank you, my Lady Chief Justice.